Namaskar. Next chapter is public interest litigation. So, in law, generally, the person who is aggrieved, the person who is injured, has the right to knock the door of the judiciary. Other person who is not aggrieved, generally he is not allowed to go to the court. Only the person whose right is infringed, who is aggrieved, he visits the court. But this right is known as locus standi. Locus standi means power to stand before the court, right to stand before the court to be heard. So when this locus standi in generally is with the aggrieved person only, when it is relaxed to other person, then it takes the form of the public interest litigation. So here we'll understand what is the locus standi, what is the public interest litigation. In short, it's and PIL and judicial activism. So locus standi, it's a Latin terminology and it means place to stand. That means whether or not someone has the right to be heard in the court. So locus standi means a person who has the right to knock the door of the court, a place of standing, the right to be heard in court or other proceeding, that is known as locus standi. The locus standi is relaxed as far as PIL is concerned. In other cases, the only and only aggrieved person can approach the court. But in public interest litigation, it can be filed by even a stranger also in the interest of the public and only against the state. So, like this, there are so many public interest litigation in the India, and Justice Bhagavati is and Justice Krishna Iyer, both are known for the public interest litigation. Now, the basis of relaxing the locus standi is that public interest litigation, it benefits or advantages the community as a whole. For example, if some aggrieved person, he is very weak, he cannot go to the judiciary, then what about his rights? If some other public oriented person, if he is willing and the cause is of general nature, then court should relax the rule of locus standi. So in this way, PIL is a legal tool which allows individuals, groups, communities to challenge government decision and activities in the court of law for the enforcement of the public interest. It serves a protection of the public interest and which directly joins the public with judiciary. So let us see this how this public interest litigation works. So we'll see this affords judicial protection to disadvantaged group also. Many times some disadvantaged persons, they are aggrieved and they are not able to knock the door of the judiciary. So through PIL affords judicial protection to disadvantaged group. It ensures that citizens have a forum to voice their concern and participate in the decision making process. And this is the effective method to be used when collective group rights are infringed, for which individual litigation is not practical or effective. Many times individual litigations are not effective. In that cases also PIL works very good. So rationale behind the PIL, we will understand what is the reason of growth of the PIL. One of the main purpose of law is to achieve justice. PIL is used by the judiciary and proactive citizens and groups to achieve this objective. The very main objective is to achieve the justice, and this can only be done by knocking the door of the judiciary, and this is done by some proactive citizens of the India. PIL is useful tool for the public with the consent to bring certain broad matters of public interest to the interest of the court or to ensure participatory democracy. So here PIL, through PIL many persons are putting their views before the court, and it forms a participatory government. This is the participatory democracy. We are in a form of democracy. So where group of persons are affected, and when that thing goes to some forum, that is known as participatory democracy. It's a practical ground of reality, and in this way PIL works very good. Who can file a PIL? Member of public acting bona fide and having sufficient interest in instituting an action for redressal of public wrong or public injury. Any person, any active citizen who knows the things, he can knock the door of the judiciary. He is not a mere busybody or meddleless interloper. He should not be only an agent. His action is not motivated by personal gain. Again, PIL is not, should not be concerned with the personal gain. It should not be biased. Against whom PIL can be filed? Very important, very important. It can be filed against Indian government, against a state pollution control board, also against private factories, and so many other institutions where group of persons are affected. So what are the advantages of PIL? Here material is given. Here we will understand what are the main uses of PIL. So it saves cost. Many times group of persons are affected by some actions. So if all persons goes to the court, it will be very expensive. So one or two active citizens go to the court and they get the justice. So it saves the cost. Provides access to justice. Some persons may not be capable of going to the court because of expensive job. So if other person is going on behalf of him, it provides access to justice to them. Reform the law. Yes. Locus standi is extender rule of the law, and only aggrieved person can ring the bell of the court. So here locus standi is relaxed. So this is one sort of reform of law. Ensure government accountability. Yes, government is accountable for each and every action being taken. So whether it is beneficially to the public at large or not, for that accountability is also taken into consideration. Raises awareness. So many pollution cases, environmental danger cases came, and now awareness is being created among the society. Empower the disadvantages. Yes, the downtrodden person, disadvantaged persons, now they feel comfortable thus that yes, there is someone who takes care of our right also. So public, some disadvantages are there. Many persons, they take advantages of misusing many laws, and misuse of PIL is one of them. It may be abused by individuals or groups to further their personal or commercial interest. We have seen in India. Lead to a large number of complex, long-lasting cases which can prolong up the legal system and create substantial costs. They prolong the issues for long period. Gives judges wide discretion in interpreting and defining the public interest, which arguably would violate the separation of powers. Yes, separation of power is given in Article 50 of the Constitution of India. Judicial action is separate, and administrative action is separate, and legislative action is separate. So many times while interpreting public interest litigations, judiciary encroaches the area of legislature also, executive also. So that is one threat. It may be constrained through existing law, which often does not reflect the current actual conditions on the ground. Now, where we can file PIL? So there are three forums. Number of forum is under Article 32, Supreme Court. Under Article 226, High Court. and under section 133 of CRPC in magistrate court. There are some other restrictions, some other jurisdiction. So all cases will not go to magistrate court, but certainly most of the cases will go to the High Court and Supreme Court. Justice, as told earlier, Justice P.N. Bhagwati is known as pioneer of PIL in India, and his name is taken along with Justice B.R. Krishna Iyer. These two juristic persons, they have evolved the bigger nature of PIL. They are father of the PIL, public interest litigation. And in India, there are so many changes taking place in PIL. Now we will understand what is the judicial activism. Judicial activism refers to the phenomena of the courts dealing with those issues which they have traditionally not touched or which were not in the contemplation of the founding fathers. It is a state of mind or origin which lies in inactiveness of the other two wings of the governance. So generally what happens, separation of power is there. Some power is given to legislature, some power is given to judiciary, and some power is to executive. Many things are in idle mode. Many things are inactive, where none of them has none of them has taken any action. So in that areas, judicial activism comes into the picture, and judicial activism refers to the phenomena of court dealing with those issues which are traditionally not touched. Like examples are there, that road safety, pollution. Earlier there was hardly any rule or regulation on this issue. Illegal structure in VIP zones, monkey menace, dog menace, unpaid dues by former and serving legislatures. So many electric bills, water bills are pending against the legislatures. Nursing admissions and admissions in institutions of higher learning. So these all areas where somewhere something we are lacking. So by the active participation of the court, many issues got resolved, and that point is known as judicial activism. So to better understand the judicial activism, first we have to understand judicial restraint. What is the judicial restraint? Once we understand the judicial restraint, we will be able to understand judicial activism also. So what is the judicial restraint? Stick to original intent of framers. I will not deviate from the whatever written in the Constitution of India. So just follow the rule. That is the judicial restraint. Use a strict interpretation of the Constitution. Interpretation varies from person to person, area to area, time to time. If you strictly follow the interpretation, then again it's a judicial restraint. If Constitution is silent or ambiguous, defer to the state and elected branches. On many issues which comes into the picture of the court, if Constitution is silent or ambiguous, there may be some confusion also, or there may be no rule on the issue. So if there is no rule on the issue or some confusing state is there, the court can ask the legislature to frame rules. So it's just shifting of the burden of that area. So this is known as judicial restraint. Now what is the judicial activism? An effort by judges to take an active role in policy making by overturning laws relatively often. So that means wherever required, wherever laws are not there, wherever constitutional ambiguity is there, wherever constitutional silence is there, wherever liberal interpretation is required, wherever original intent of the framers are not clear, there the judiciary can make their stand clear, and that is known as in solving the problem. They can make their stand clear in solving the problem. They can found the solution, practical solution, and that is known as judicial activism. So when we understand the judicial restraint, we can understand the judicial activism also. So like this, we can understand the public interest litigation. Public interest litigation is very important topic. Here we have understand only 3 points: locus standi, public interest litigation, and public interest litigation and judicial activism. Yes, little bit difference is there between the PIL and judicial activism. PIL is the part of judicial activism. Judicial activism came into picture, and so many things took place out of that. PIL is one of them. So in fact, judicial activism is mother of the PIL, and PIL deviates the standing of local standing. So this way we can sum up what is the locus standi, what is the PIL, and how PIL differs from the judicial activism. From probation clearance point of view, it's also very important. Only important topics I am touching, and I am just giving you a brush up idea. I am not going into depth. Otherwise, it will take very long time to understand for you. So just I'm giving a overview so that your concept should be clear and you can reproduce into the examination hall. We'll meet in the next class. Till then, namaskar.